there any other questions? Should you ever apply for all types of patents for the same invention? Excluding plant patents, we do have cases where we filed both utility patent applications and design patent applications. And if the product, I was discussing with someone last week, I'm encouraging them at some point they may want to consider registering the shape of the product as trade dress. So that would be 3 different types of protection for the same thing. Copyright doesn't cover useful articles, so you can't claim copyright in like the shape of a telephone or the shape of a lamp per se, unless the shape of it, the ornamental appearance of it, could like exist separately or independently. So if the base of your lamp is a sculpture, you could claim copyright in that as a sculpture. So that's kind of a distinction there. So you could do all those types of protections for the same type of same product. How can you prove obviousness once something new has been? How can you prove non-obviousness once something new has been invented? I'm not 100% sure I understand the question, but in terms of arguing non-obviousness to the patent office, it's really just basically, the first step is to simply argue with the examiner, well, the prior art doesn't really teach or suggest combining these types of references. That's the type of argument we make. And there's some other terms of art from the case law that we've developed that we make these arguments. And then if you really get in a position where you can't convince the examiner that it's non-obvious, there's certain indicia of non-obviousness that we can assert. For example, if there's been a long-felt but unmet need for a solution to a problem, and if you can submit evidence of that and then submit evidence that your product solves that problem, that's indicia of non-obviousness, and I've used that a couple times successfully. If the product has become a commercial success quickly, and if you can combine it with that long-felt but not unmet need evidence, that's also indicia of obvious. Basically, the argument is, if it was so damn obvious, how come no one else came up with it before? And if sales go out skyrocket, you say, there was a monetary incentive to do this, so that's indicia non-obviousness. If the prior art teaches away from it, you can argue non-obviousness. There's one other, and I can't think. Others have tried but failed to solve the problem. So there's different types of approaches you can do to address that. Did you have a question? And then, if I copyright a book with recipes, does that cover all the individual recipes? Again, that's another tricky question. So technically, the basic recipe by itself, the ingredients that you're going to use, the list of ingredients by itself, just in the abstract, is not protectable by copyright. It's your expression of that recipe. So the way you've written up that recipe, that can be protected by copyright. But you can't use copyright law to prevent someone from coming up with the same basic recipe and just writing it up differently. And so on the book, arguably, if they copy one recipe the way you've written it up and you've registered a book on all the recipes, that's probably enough to give you standing to sue for. That registration covering that book is probably good enough for you to sue for infringement. If you do photographs are, you hate to have to do a separate registration on each photograph, so there are ways to do groups of photographs at one time. Greeting cards is not as easy, but that's a different topic. Any other quick questions? Yeah.
Excuse me. I've been writing songs for a long time, and I haven't gotten copyrights on any of my stuff yet. I did some research way back, and at that time, I think one of the books I was reading was saying that to prove ownership, you could like mail yourself something. And, I mean,
So those are the poor man's copyright, poor man's patent. All that does is just provide evidence of creation. It doesn't, and I guess it could be useful in a court of law if you had to provide when you came up with something to show that you didn't copy someone else.
Sure.
But, and it could come up with when you created it, if there was an issue. So that, it's just evidence of creation.
Okay, so if, you guys represent any, like authors or musical artists or anything like that?
The firm does have some, not a lot.
Yeah, I was just curious, like if I had a collection of songs, for example, that would probably be more cost effective to get those copyrighted at all at once.
Yeah, there's a guy in our firm, Arthur Chaikin, who's more familiar with the, he's done some work for a guy who does greeting cards.
Mm-hmm.
I'm not sure songs are difficult, one, because there's a copyright in the lyrics,
Right.
there's a copyright in the score,
Right.
there's a copyright in the sound recording,
Right.
so there's at least 3 different copyrights you're usually talking about.
Yeah,
And so it can get complicated. Not to turn away work, but there's some other, there's a guy who does copyrights in music. I can't think of his name. He does a CLE, a continuing legal education program, a couple times a year on copyright law in music. If you give me your name, I can find his name and email it to you.
Okay.
He's probably a much better, more knowledgeable about that.
Yeah, I think he's in Topeka, I believe, or in that area, but,
Okay.
but if you search, I think he bills himself the rock and roll lawyer, does the CLE, so.
Cool.
Any other questions? Well, thank you very much, and hopefully you learned something today.